Well, I actually like to start on time, so we're going to start on time. Welcome to the North Coast State Library's Ask Me Anything on Copyright. I need to state right off the bat, I am not a lawyer, so any information I share is meant to be for informational purposes only. It's not meant to be a substitute for real legal counsel. So go find a lawyer. If you need help finding a lawyer, the State Library can try to find one in your area for you, but oftentimes your city or your school district has access to one for you. What I am is a librarian who's worked at the North Coast State Library for the last 18 years. I also have a lifetime love of books and reading, and I have a semi-healthy respect for the law. So I got one question, which makes the Ask Me Anything part of this a little hard. I'm going to answer that question near the end of this thing, but instead we're going to go over a few of the basics of what is copyright for libraries, fair use, rights, CCL and CCG, and how to be federally compliant. I've also included some resources I've used myself that will I hope help you guys understand copyright a little better. So the United States copyright law is Title 17 of the U.S. Code. It covers all forms of tangible expression, either written on paper, recorded on tape, or coded into a computer. Works do not have to have a notice of copyright to be protected by the law. One should assume that all works that are created on or after January 1st, 1978 are copyrighted unless otherwise indicated. The reason why copyright exists is to give the creator control, otherwise known as exclusive rights, for a limited amount of time. After that time has elapsed, the work falls into public domain where it's free for anyone to use. During the time copyright is granted, the creator controls reproduction, derivative works, distribution, public performance, and public displays, and in the case of sound recordings, public transmission by means of digital transmission. With reproduction, no one other than the copyright owner may make reproductions or photocopies of the work. So only the owner can photocopy a book, copy a computer program, use a cartoon character on a library wall, or put a portion of their song within another song. Derivative works is kind of like reproductions, but with a twist. In the library world, this means taking a novel and putting it into large print format or into an audiobook. It also controls turning the novel into a movie. Distribution. This allows the copyright holder to control how the work is made available, either through the sale, rental, or lease or lending. However, the right of distribution is limited by the first sale doctrine. Once that item is sold for the first time, the copyright holder can no longer control what happens to that copy. This is why libraries are able to function as we are. Public performance is kind of self-explanatory. A place is considered public when the work is performed in a place open to the public or at a place where a substantial number of persons outside of the normal circle of a family and its social acquaintances are gathered. So showing a movie, playing music, or doing karaoke in your library is illegal due to this right granted to the copyright holder. Public display goes along with public performance. The copyright holder has the right to display individual stills from a film, paintings, drawings, sheet music, sculptures, or photos. It is important to note with public performance and display that it can happen directly or indirectly. Indirectly can be seen in many YouTube videos of small children dancing to music, or an underlining musical track during your recording of your story time, or why your copy of WKRP in Cincinnati isn't quite the same as you remember it. The copyright holder of the music playing in the background has control over how their music is used. Therefore, they usually demand payment for using their item in the background of a video. The same rule can go with images. This is why you often see t-shirts or other background images fuzzed out of certain shows. That way the show doesn't have to pay for their use of the image. And now that we've covered some of the rights that the copyright holder has, let's see how we can get around that. Fair use is when an exemption that provides several instances where reproduction is permissible for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, and therefore is not an infringement of copyright. However, all 4 factors must be considered. You can pass one, but still fail the other 3 and be found liable. The first factor is the purpose and character of the use. This is the only factor that deals with the actual use of the item. This is where you're going to examine if you're going to use the item for a criticism, comment, etc. Nonprofit use also favors fair use in this factor. So for-profit education is in a bit of a sticky place. The second factor is the nature of the original work. One element of this is whether the work is published or not. It is less fair to make someone else's work public within your own before they have chosen to do so. Another element is whether the work is more factual or more creative. Borrowing from a factual work is more likely to be fair than borrowing from a novel, which is a creative work. This is related to the fact that copyright does not protect facts and data, so a textbook is more factual and easier to prove fair use on than a novel is. Factor 3 is the amount and substantiality of the portion used. Now, this is the element where a lot of bad advice is given. There is no mathematical guideline of how much an item can be used that covers fair use. So forget that 10%, it does not exist. Of course, a smaller amount of an item that is used will probably favor fair use, but the amount is proportional. A 250 words used out of a 300-word poem is probably going to be frowned upon, where 250 words out of a many thousand-page article is probably more fair. The second element of the factor is the substantiality, which asks whether you are using the heart of the work. So the hook of a song is more important than other parts of a song, and the climax of the book is going to weigh more against fair use than other parts of the book would. Factor 4, the effect of the use on the potential market value. Now, this one's a bit tricksy as it's asking people to analyze the work and the potential markets that their use would have. The user then gets to predict what they would have on this market. More simply, are you using this and will it take away a sale from the author that he otherwise would get? And then there's the fifth factor. I know, wait a minute, I said at the beginning of this that there were only 4 factors, and there have only ever been 4 factors, but the 5th factor is still relatively new and not really recognized. But in 1994, the Supreme Court sort of added transformative use. Now, a derivative work is transformative if it uses the source work in completely new or unexpected ways without really changing it. So parody is often mentioned here as it clearly transforms the original piece. New technologies can also fall under transformative. Image search engines make copies of images and then make them searchable. The court ruled these are transformative as the copies were being made for indexing rather than for simple viewing. Transformative use is still new, so there's a lot of room for argument and interpretation. Well, now you know if your use of an item is fair and you need to go get a copy of it. Part of the copyright law states that libraries are allowed to participate in interlibrary loan as long as aggregate quantities of articles or items received do not substitute for actually owning the item. This statement is a fine line of balance between librarians and patrons who want everything and publishers who really don't want to give you anything. Because of the law's lack of specificity, the National Commission on New and Technological Uses of Copyright Works, otherwise known as CONTU, developed a set of guidelines to provide specific quantitative guidelines, and this is where your CCL and CCG come. You can ask for 5 articles from one title during 1 year if the articles are 5 years old or newer. These requests are referred to as CCG as they match the guidelines of the copyright law. On January 1st of every year, the article count starts all over again. If anyone from the federal government shows up at your library asking how you comply with the copyright law, you need to be able to show them the periodical titles you've requested CCG articles from for the current and the past 3 years. You don't need to worry about tracking anything older than 5 years, as those are all CCL and they comply with the copyright law. This helps publishers and maybe some authors feel that the newest and most desired information is protected for a time. And now for the only question I received. Jennifer from an unnamed school that is definitely, most likely, probably isn't in North Dakota, asked about musical copyrights. For instance, before games and during halftimes, they often play music over the loudspeakers. She thought this was illegal since she knows that only small clips or percentages can be broadcast or used by students during assignments. Well, I'm going to give you the most famous answer in the library world. It depends. Obviously, you know it's wrong because music is intended for private home use. However, licenses can be purchased that would cover this type of use, either from the music companies themselves or from other companies in places like Pandora that offer Pandora for Business. Movies also have companies that sell licenses that cover public performances. So now, where do we go from here? And I want you to realize I did not sing that because that would be against copyright and we didn't purchase that. There are several good resources to turn to if you want to learn more about copyright. One is the frequently asked questions page of copyright.gov. It's a good place to go because it's run by the Library of Congress. ALA and the Association of Research Libraries also have excellent resources for libraries and copyright. If you're looking for books, I would recommend books by, leaning back here, Carol Simpson and Carrie Russell. This way. Both have excellent and down-to-earth ways of answering copyright questions. But honestly, I would hold off on buying print resources. The world of copyright is set to change, and hopefully soon. For years, people have been referring to copyright as a broken system. The politics of copyright have always been contentious, and especially in the digital age. Right now, steps are being taken to modernize copyright, but they appear to have been stalled. So who knows when the next update for copyright will occur? When it does, I'll try to come back and maybe offer another Ask Me Anything. Until then, feel free to call or email me with any questions you have. That is the end of my little statement, and if you have any questions, you could type them in. I don't promise to answer them because I don't know how weird they'll be. I can also collect questions later and email you back the answers.
What about digitization?
Digitization was a question that was asked, and I have to ask you to be more specific of what?
County Heritage Books by Centennial Committee.
My favorite. So those were definitely put together. Now, it depends on how old the county is, whether you're going to find any of those people who worked on that book still alive or not. If the book was put out by the town, that's who you're going to have to call, because yes, they were definitely probably all done after 1978, so they all exist under copyright whether or not they registered them. So your first place would be probably to contact your city auditor and find out who owns the copyright, because you will need their permission to digitize it and make it available through digitization. Another good person to ask on this, unless it's the person who's asking this question, would be Stephanie Kalm over at the Historical Society, because I know they have been working on getting some of these county history books up on digital horizons. I guess I could also talk a little bit on karaoke in the library, which was a question that I've seen bandied about. Yeah, it's kind of illegal. Sorry. How you can make it legal is actually getting CDs that are intended for karaoke, because they cover the copyright for you when they're played. And music copyright is a bit weird because you need to get the copyright cleared for the music and for the words, because it's two different copyrights for those. Or you could instead put on a lip sync performance with things on YouTube. As long as you're not the one running it, you're not the one liable, which is also kind of fun.
If you buy the CDs, though, you can do it.
If you're referring to lip sync or playing in gyms, the comment was if you buy the CDs, you can do it, and you're referring to the first sale doctrine. No, actually you can't, because you're a library. You're a library and you're a business, and that's different than an individual who is buying that. When you buy it, it's intended for one use, limited home use. You have to buy it with a public performance license, which some videos you can, but those often run into the 150 single one purchase. Karaoke CDs. Yes, if you buy a karaoke CD, then yes, you can do it, because that's where you're getting your money and they're paying the copyright on your behalf. I thought you meant like maybe showing a video in your library. Yeah, no, don't do that. I know it's really nice to maybe throw that DVD in and like show your kids at story time, but it's not legal.
What about the Digital Care Fund streaming karaoke? Do they take care of that, or do we?
That is a good question. The Digital Care Fund streaming karaoke is not something I am familiar with. I would go into there, and if you send either myself or your library representative, I think that's Brianne, that link, maybe we can look into it for you. But they should list on their About page how they take care of you for copyright purposes.
Another question is, what about patrons printing pictures and information from the internet?
Yay! So printing, your patrons printing. You should all have signs, and I should have covered that, in your library that state above your copiers and above your printers that by printing items, they could be found liable for infringing on copyright. However, if you don't have that sign, you are liable if they come into your library and print out. If you do have that sign, you are not liable, the person is liable. So you definitely want to have that sign. I will put up a link on our Facebook page to where you can find the wordage for that sign, so you can all print it out and hang it above your printers, because you really need it. We should have did this.
Do you have a template for that sign?
Yes, the Library of Congress has made a template, and I will make sure that I send you the link that sends you to one you can just print out.
Do you know what the exact wording is?
Off the top of my head, no. I'll have to go look or run out to our printer, which has it above. But I do not know off the top of my head anymore what that exact wording is.
What about helping patrons to print?
You're still just assisting them. They're the ones that are actually doing the printing. If you were printing it for yourself, then yes, maybe you would be found liable. But no, it's still the person that's asking for it to be printed. Plus, you don't know what they're using it for. They could be using it for private home study, which is totally legal. I don't know where some of those like popular pictures and stuff like that they're printing out might be used as private home study, but who knows what they're studying? Maybe they're studying Kim Kardashian's latest hairstyle. Who knows?
The next question was helping patrons to print items from the internet.
As in actually help, as long as you're helping them to print out, that's fine. They're the ones that are going to get in trouble with the copyright law. But you can't assume what they're using them for, because it could be private study, and that's totally legal. And, once again, feel free to email and ask me any questions. I'm available. Okay. Well, if you guys have no other questions, we're going to end it now. However, feel free to get a hold of me. I'm at the State Library. My direct number is 328-3252. My name is Sherry. Thank you all for joining us today. It's been lovely. Bye.